So, a very good evening to everyone present here. I am Riddhi, Head Coordinator at LawInternships, the online law school, and I'm the moderator for today's session. So, we have amongst us Mr. Akaant K M, sir. Sir is a practicing lawyer at the Constitutional Courts and the Company Law Tribunals. He is a UGC NET qualified and currently also a visiting faculty at the National University of Judicial Sciences, Kolkata. And Sir has recently authored a book commentary on insolvency and bankruptcy code, law and practice, which was forwarded by the Justice Suryakant Judge, Supreme Court of India, and published by the EGC publishers. He has several publications in Hooper's journals and is a guest columnist at SCC Online. We welcome you, sir.
Thank you so much, and thank you for inviting me.
It's our pleasure, sir. So, today, sir will be discussing with us the art of doing a legal research, and sir is a very expert in that field. So, today we are going to learn from him how we can do legal research. So, if in case, in turns, any kind of questions you have, you can ask from sir after the session. And please unmute yourself whenever you ask your question one by one, or if you wish, you can write your question in the chat box. I also request the interns to kindly turn on their videos for making the session an interactive one. So without delaying any further, let's begin the session for today. Over to you, sir.
Thank you so much, Ms. Jindu, and thank you for the introduction that you have been very kind with. Um, so, today's topic is how to do legal research. I think, to be honest, let's just start from how I started going about this. When I entered the law school, I had zero idea how to do research. For many of us, the only way of researching was just a Google research and then find whatever Wikipedia comes up with. When the day we started our
Excuse me,
graduation
sir.
course, the undergrad course, yes,
Sir, your voice is breaking, sir. Sorry to interrupt.
yeah, is it audible now?
So it's
Yes, sir.
breaking a bit.
Yes,
When
sir.
you're
It is
speaking.
audible, but you are breaking. Your voice
Hold
is
on.
breaking.
In case if it's still subsisting, I change the location then. There must be some problem because sometimes the internet does not catch at a very good bandwidth. So in case, so are you able to hear right now?
So it's breaking little bit when you are speaking. It's breaking.
Wait.
Yes, sir.
So like I said, so just to start off, when we had entered law school, so our experience was similar to that of any person who just cleared their plus two. So we would only go by Wikipedia. And the first day of our law school, our teacher suggested right away that whoever is going to research on Wikipedia, they can forego clearing the exams to begin with. And we were shell shocked because we used to think that Wikipedia, having a good grasp over how to read from that, having a good reading speed is all that matters. But then we sort of started getting into the issues, fundamental issues. Is it still not?
It's breaking. Like when you're speaking, there's a weird noise coming from your internet. So you're not audible. Yes, sir. Perfect. Now perfect, sir.
Yeah. So, so we'll just restart again. So how I apologize for this problem that keeps coming up because a lot of times we also face it. And in fact, I had faced the brunt of bench in one case. They right away adjourned our case only because the network was not good enough for them. So yeah, to restart, the first day of law school, we were told that there is something to effect which is called authenticity. Now, a lot of times what happens is, as fresh students of law, we tend to think that whatever is read on a blog or a random article, that carries weight. Instinctively, our mind goes that yes, this is what I want to go about. Like, this is what I was looking for, and this is how this entire picture is getting set. So we'll pick up those lines to support our case. So for the purposes of an illustration, I'll just mention that in our first year of law school, we were doing internal moot court selections. So I was taking part in that, being the researcher in that team. What I did, that the topic was of arbitration, and in that case, it was that the arbitral tribunal was comprising of two arbitrators, which was even in number. So the Indian Arbitration Act says under Section 10 that the number shall not be even number. So this was the issue, and the interpretation of Section 10 was the major crux of the problem. So what I did, I just went into the library, picked up Halsbury's Laws of England, picked up Corpus Juris Secundum, and just randomly started going into the index. Now, one thing that I want to clear out, a lot of us feel that index means what is there in the front of the book. The starting pages of the book, we tend to say that this is the index. This is not the index. That starting detailing the subheads and heads of the entire subsequent chapters, all that is part of table of contents. That is not index. What is an index? Index is at the last of the book. You take up any book, except for fiction, you will always have the last of that book, the last pages of that book, it would have the index. Index basically means the keywords during the course of the book. So for example, I'm reading a book on, let's say, idea of justice. Now in idea of justice, Amartya Sen discusses upon various aspects of justice. One is utilitarianism. Second is libertarianism. Third is egalitarianism. And then he's going about other intricacies in these subjects. Now, how would, as a reader, if I have to recapitulate, how am I supposed to know, or if I have to refer to that book, where in that particular pages he's referring to this particular concept, how would I know? So I would go to the index, look for the keywords, and from there, it would provide me the relevant pages. For instance, page number 10, then page number 50, then page number 250. So this is how the indexing would be done. The indexing basically means the keywords that are given. So what I did, I went to the library, I opened up the index part of all these commentaries, and then started looking for even number of arbitrators. Now, what you have to be cognizant of the fact here is that I had no idea what was the parent law of the legislation. So if I'm referring to Halsbury's Laws of England, I'm only going into what the England position there is, but I'm not referring to the legal proposition that is there, what the statutory law says. I'm not going into that. What I'm going there to find out is, wherever the word even number of arbitrators has come up, I took it up and then wrote it down in my memorials for the purpose of research. This is how I made my first memorial during the law school. Now, a lot of people, so this is how we tend to grow. Now, we started subsequently during research, we consulted with a lot of our seniors. So they told us that look into Manupatra, look into SEC Online. So I said, very well, we'll look into that. Now, how did we go about in Manupatra? I've always preferred these search engines because they are always the keywords. Once you type in, they give you good amount of results, and there is always the option of filtering out. So in Manupatra, what I did was I just typed in the keywords, then started looking for the hits that there are. There arose one particular problem. What happened is, so if I write down even number of arbitrators, Manupatra start simply like as an example. Let me just share the screen now so that you may see how how to do research on Manupatra. How do I share my note? Yeah, is it visible to you?
Yes, sir, it's visible.
Is it visible
Yes,
to
sir.
you? So how did I go about this? I just simply type even number of arbitrators, right? So it is giving me hits of all the judgments that are relevant to my case. Now it is giving, so in a lot of cases, even number of arbitrators is coming here. As in when I started dwelling more into that, I started noticing there is a difference. We will not be finding the exact phrase. What Manupatra would be doing, at in one particular judgment, it will look for even, it will look for the word number and arbitrators. So in any case, even when even number of arbitrators, I'm looking for this exact phrase, I will not readily get. So what I do is, I quote it. When you put it in quote marks, in quotations, this exact phrase will come up every time. Now imagine you are researching on certain words which you know very well that it may take up the space of entire sentence. So words like waiver of an arbitral of a right, arbitral tribunal, even number of arbitrators. So waiver, even number, and arbitral tribunal. These three phrases will not form part of one sentence, but they will always be near. So for the purposes of my query, I want these words to be near. So how do I get go about this? I could say the estimate that within the search of 10 words, I find these three words: even number, arbitrators, waiver. So basically, this is the only judgment where this is coming up. Otherwise, if I search for, let's just say, yeah. So what I do is I find these three words within a space of 10 words. I find these relevant queries, waiver of objections, and in that we'll find arbitral and tribunal as well. So the idea generally is to give you some insight on how these words can spread and how you can look for those words within those three. Manupatra SEC, they have certain differences on how they go about in their search engines, but they are very efficacious tools for you to research on. So whenever we are to research, so earlier I was researching on a case, minimum wages to be paid. So minimum wages to be paid to an employee, then remuneration, all these keywords were there. So I'll right away, I'll start off, say, minimum wages. I'll just type simply this query. Once I type in this query, if I feel that maybe I need to filter it further, so I'll do search in the results. So in my case, what happened was the bench had posed me this query that minimum wages that you are asking for your client, that he's not being paid minimum wages, but the contract of that person says remuneration, whereas the Minimum Wages Act says wages. Then what I did was, then I started looking into remuneration in that result. Because anyway, my question was primarily about minimum wages. Then I had to start looking for judgments which have specifically gone into this, the words of remuneration. So once you look into words like remuneration, you'll find all these stray results. It says sort by relevance, but inevitably you end up going through a lot of judgments. But the easy way is just to keep opening all these tabs, then Command F or Control F, find remuneration. So this is, you find that the dictionary clause of 1948 Minimum Wages Act, it itself defines wages as all remuneration. So this is a very easy way to look for queries. It is easy in the sense that you do not have to go beyond the comfort of your office. You do not have to go beyond the comfort of your laptop. It becomes a little tedious and little monotonous because you end up typing synonyms of a particular query. For example, if I am to research on constituent assembly debates. Now, constituent assembly debates, I will look into, say, a constituent assembly debate. They have subcategories. So if I have to divide those debates, one would be what are the speeches made in the constituent assembly. Second, what were the reports presented during that assembly session. Third would be what were the drafts, the previous draft of the constitution and the end draft. So all these things are sub parts of that. How would I go about this? My topic was speeches, constituent assembly debates. I simply wrote here, this is what I get, all the results that there are to receive. So what I do, search in results, I start finding out what I say Ambedkar. So for the purposes of my query, speeches made by Jawaharlal Nehru, B.R. Ambedkar, Sardar Vallabhbhai Patel, they were of utmost importance. Whatever speeches, whatever queries they replied to in the assembly, they formed a very important part of discussion. So I started finding these judgments. Because now you can see, it says procedure of appointment. Now it is going into some Bangladesh secretariat. So what I did was, I simply looked into Supreme Court of India. So the results of Supreme Court of India judgments, where they have referred to these specific words, speeches, Constituent Assembly debates, and Ambedkar. So once I looked into that, I saw all these important judgments. What you can see here is the number gets completely reduced to 63 results. Now you know that you do not have to go beyond these 63 judgments to look for Supreme Court judgments on the issue of speeches made by Ambedkar in the assembly debates as part of Supreme Court debates. So this is one particular way that one can go about this. Second, alternatively, I would also say, like, if you are researching on Google, so Google it is one of the most handy tools that there is, and I think if one is able to understand how to use it, they can do wonders with it. So, for example, if I am to research on, say, insolvency and bankruptcy code, so I need to know more about what is there in with respect to law of limitation. So law of limitation and insolvency bankruptcy code, I have to prepare for an interview. So I know some recent development, if there is, it will give me additional benefit of sounding to be updated with the current affairs. So what I do is I'll type in insolvency bankruptcy limitation. Once I do that, you may see articles of November, April 2020, December 2020. But you need to understand 22nd of March, the Supreme Court decided and gave a very important judgment on this subject. What you can see from simple Google research, they are showing you articles of November or 2020 basically. What you do is go into news. What do you find here? You find the latest judgment that there is. You find 3 days ago judgment, 21 hours ago. You find the latest jurisprudence that is coming up on this issue. So this is a very effective tool in helping you on finding out that whether this particular research, whether this particular issue has any recent developments. Now coming to SEC. So SEC is one of the most powerful tools for any person to do research, because they have been doing collating data for a long time. Since time immemorial, SEC judgments have been accepted in the Supreme Court, in the High Courts. There are other portals such as Law Finder. So in Punjab Haryana High Court, a lot of lawyers, they use Law Finder as a tool. However, I have only preferred SEC Online because A, the authenticity is already proven. B, the case notes, the head notes of SEC, they have heavily invested into making good and very concise head notes of a particular judgment. So any person who wants to go and just have a judgment downloaded and then go through it, they should always try out for SEC or Manupatra. These two tools have been, they have done wonders for me as far as my legal research is concerned. In our university, we used to have LexisNexis. LexisNexis was very helpful to the extent they used to give you insight into other jurisdictions, and they used to cover US case laws a lot. We were preparing for a moot court competition, which was on insider trading. So for insider trading, a lot of research was to be imported from US. We looked up, so I researched heavily from LexisNexis that time. They go into US circuit court cases, the appeals in their local courts, everything. For English cases, we have seen Westlaw as one of the most efficacious tools that there is. I do not know how many people, so my university used to give me remote access while we were still the students, but now we still, even now we also don't have access to that. But for English cases, Westlaw has done remarkably well. Westlaw is there. For UK, for US, LexisNexis does a good amount of work. For Indian cases, Manupatra and SEC. Then I would, a piece of advice, try and refrain from Indian Canon. So Indian Canon is readily accessible and very good. I think I would always be appreciable of the fact that Indian Canon is an open access database, and any law student, any lawyer, they can easily research. So for example, when you're writing a post on a blog post, you hyperlink Indian Canon links. But what happens in a lot of cases, somehow the citation is different, the name of the case gets different. And Indian Canon is not accepted by, say, researchers, scholars, teachers, and judges. But that being said, it is still a boon for any law student and a lawyer to have Indian Canon at their fingertips. Simple Google research helps you in finding it, whatever judgment you're looking for. So I think as far as search engines is concerned, we have more or less covered on this. Third part, which I would say, is how to read a judgment. Now, this is one tricky part that has come up because when in my experience, how I started doing was I simply started going into taking lines from a book, or I would go through the judgment, control F or command F, the relevant word, without seeing whether this is what the court is holding or is it just a submission of the counsel. So what happened is a lot of my arguments would started making no sense at all, because the moment the judge of a moot court competition would ask me that is this what it was, is this what the court held, I would have no answer to that. So for example, you see here, is this judgment still visible? Which is,
No, sir.
are you able to see Manupatra?
No, sir. I can see only the Google one.
Let me. Yeah.
Yes, sir. Now it's visible.
This judgment is visible now.
So we can see the Manu
Are
Patra
you able
screen.
to? Okay, so let me share the. So what is visible right now? A judgment or just a Manupatra page?
So Manu Patra page is visible.
Now?
Yes, sir. It's visible now. Judgment is visible.
Yeah. So what happened for my research, how I fell into this policy, I simply went into what the submission was there, which was basically, I said that, my lord, there are matters from which a party cannot derogate, and those are provided under section 4.8 this, and the matters from which a party can derogate from are contained under this provision. So the judge asked me that how are you saying this? Because see, everyone who were well versed with the judgment, they knew what the court held. My mistake was to look into what the court did while recording the submission of the counsel. You can see that Mr. Venugopal submits section 4 of the would apply only this, and the party still proceeded. He submits that in respect of this. He submits. So clearly this was not what the court was holding. The court, so you have to understand the court, what was the court's observation? We are also unable to accept the submission. This is what the court was discussing. This is court's contribution in our view. Before that, whatever they were discussing, it was just a matter of what the councils were saying and they recorded it. On the other hand, Mr. Dwivedi submits, the other council submits. So my point being, in a lot of cases, what happens is even lawyers, you'll be surprised to see a lot of lawyers falling into this error. What they'll do is they'll solely rely on a case note. The case note sometimes is not very effectively made. So if a very incompetent case note is being prepared by a researcher, it makes you all the more look foolish before the bench, because you have not gone into the judgment. You are relying solely on the case note, only to find out probably the case note contains the contentions by one of the counsels. So thousands of arguments are made in the court. The court records every bit of it. There are so poorly written judgments of the Supreme Court, High Court, let alone not going into the judgments of High Court. The Supreme Court, many landmark judgments, you'll find hundreds of pages just recording the submission of the counsels. So you'll be surprised to see that Indian judgments, they lack so brutally in their quality, it is a painstaking exercise as it is to read a judgment of a Supreme Court. Very few judges take the pains to properly write a decision, probably because they are overburdened and probably because they are to give judgments on topics in which they have not really done their practicing, or they have not really engaged that much. So, for example, a lawyer like uh, Nariman, he has done a lot of work in arbitration side. So, and commercial side, he looks very well and very comfortable the moment he is writing a judgment on insolvency, bankruptcy, or arbitration. I'm not going into the merits of those decisions, but say if you give this particular judge, say a case on TADA or IPC or CRPC, that person may not be that comfortable. Similarly, Yu Lalit, he was one of the prominent criminal lawyers before he became judge of the Supreme Court. So I'm not sure how much he will be effective and quick enough in terms of commercial laws, say customs law. So every person has their own expertise, and the quality of judgment gets affected or eroded to that extent. As a researcher, as a reader of judgments, as a lawyer, our role is to find out what what is the pattern that is there. For Indian judgments, you will start noticing the pattern that what they do is they start recording the submission of the counsel first and foremost. Second, what they do is they refer to the provisions of law and reproduce that. Third, very few judges do it, but it still happens that in a lot of cases, judges would actually make subheadings, counsel submissions, our analysis or our opinion. Otherwise, you are the one who is to go into this particular detailing that how are we to find the ratio descendant. This is also one of the challenges of reading a judgment, that when you are going into a particular judgment, you must be cognizant that the court says n number of things. They will, for like this judgment which we were reading. So you would see that the court was writing, saying everything that we are not able to accept this submission, even otherwise under this. But what we have to be categorical in is that we have to find, in our view, section cannot be read in the manner as suggested. What was the issue in that particular judgment? This is what forms the crux of the query that you are posed with. You may rely on the obiter, but you need to know the difference between obiter and ratio descendant. A ratio decidendi can never substitute and can never be outweighed by anything else. If a court is holding one particular thing, you can be assured of this fact that this is the be all end all. Nobody can take it away from you. But to find that pristine singular truth, it takes time, and it takes not taking the easy way out. Because when we are researching, we also have this temptation that this is the best I'm getting, so let's go ahead with this. Just take a step back in this. Do not get tempted, because even if you do not find anything better than this, at least know that you do not have better stuff. Never present what you have as the sanctimonious truth that is there. So in that, so I'll let me show another judgment to you. So you'll be surprised to see that how often this problem comes up and how often the court is asked to decide on these issues, how the judgment is to be read. Sometimes the court itself confuses that whether our previous judgment is decided properly or not. Yeah. Yeah. So this is the judgment of the Supreme Court, where the Supreme Court was discussing. So this is, yeah. So as you may see that this is a judgment of Supreme Court in 2019. So the issue was one of the precedents that was given by Justice Nariman only. He is the author of this judgment also. And there was a precedent of his that was in question, which was Indus judgment. So what happened was in Indus, the court held that the seat of the arbitration is conclusive. For example, if Mumbai party is there and a Punjab party is there, they are entering into a trade agreement. So Mumbai is the supplier, Punjab is the consumer, a company in Punjab is the consumer. But the arbitration agreement says that all the disputes will be settled by an arbitral tribunal seated in Delhi. The question was which city has the jurisdiction in arbitration. So the court's criticism was given of Indus judgment by a lot of people that the court in Indus is wrongly understanding this. The jurisdiction has to be given to Delhi as well as Mumbai courts. In any case, not to dwell into the merits of the case, so the court is referring to its own precedent. After clearing the air on the meaning of Section 30, this court made it clear that the moment a seat is designated by the parties, it is akin to a jurisdiction clause. Now you have to see what the court says. Despite the aforesaid judgments of this court, discordant notes have been struck by some of the high courts. In Anthrics, a division bench of the Delhi High Court says something to this effect. Then the view of the Delhi High Court, which followed judgments of the Bombay High Court. The court says it does not comment to us. The court further says that the ratio of the judgment in Indus is contained in paras 19 and 20. Two separate reasons and distinct reasons are given by us for arriving at the conclusion. The first reason is independent of the second. It is thus wholly incorrect to state that Indus has a limited ratio descendendi contained in para 20, and that para 19, if read by itself, would run contrary. So what we see here is the reason I dwell more deeply into this judgment is to help you understand that we are only law students or lawyers are not, they do not fall prey to this. Every person, every court can misunderstand or misconstrue a judgment. So the court in Indus had given judgment, it had given reasons in para 19 and 20. A lot of people wanted to scuttle para 19 because of the consequence it had intended. When the matter came up before the Supreme Court again in another case in BGS in this present judgment, the court categorically stated that no attempt should be made to scuttle what we held in the judgment of Indus. So what we have to here understand is that finding ratio decidendi as well as trying to find what are the reasonings used. These are two separate things. If the court says that, say, Section 10 of the Arbitration Act is categorical to the effect that no arbitral tribunal can be of even number. This is how the court holds Section 10. This was the only issue before the court. But say in other paras, it says that in Section 34, public policy does not mean that you will open these queries. Once you understand, so like this idea which I'm trying to put across is that you cannot go into these specific issues with your eyes blind shut. You have to be cognizant of what the specific query before the court was. The court says n number of things, and it is a sort of a very poor reflection on the way our judgments are written. But courts tend to dwindle into a lot of other areas, and sometimes as a matter of as a matter of reasoning, you end up discussing a lot of other provisions, but that does not have to mean that this is what the court is holding. Because in order to arrive at a particular interpretation, the court also refers to certain other provisions in the statute to say, no, the legislature used the words wherever it intended to in other provisions like this. In this provision, it only used the word may. In other provisions, it used the word shall. So we should know that the legislature was very clear in what words they were using, for example. But that does not mean that they are also deciding on those provisions. I think these are certain points which I wanted to clarify, because as legal research, this is one of the most common fallacies we have always fallen prey to. And just to recapitulate, one of them is Wikipedia. Second is how to do research on Manupatra or SCC or Google for that matter. Third, how to find ratio decidendi and obiter dicta, how to differentiate between them. Fourth, as a general principle, I would always say try and stay away from case notes. The head notes, case notes, they can never be of any help. I think in honest terms, I never gone through a head note myself. I've always gone through the judgment. It has always been easier for me to go into the judgment rather than find the case notes. Because when I'll end up writing about the judgment, I would get confused myself because the logical inconsistency would be there. That logical consistency would always be there once you read the entire judgment. Ms. Jindal, I think this more or less sums up what I had intended to share.
Yes, sir. So interns, do you have any questions? Any one of you have any kind of questions
Yes,
regarding
ma'am, I
legal
have one question.
research? Yes, Vishal.
Sir, you have said that you are writing a book. So, sir, I am trying from last various months to write a book, and I also choose up one topic at 21st century, and I started to work. But sir, I am not somehow complete it. So, can you sir please tell me how to complete it, or how to start, or how to finish one complete or one very good book?
See, I'm not writing. I had written. Currently, I'm not doing anything of that sort. But see, writing a book, it depends purely on what sort of book you're writing, the area of law you're writing on, and the extent of research that you're going into. So for my purposes, if it helps you in understanding, so when I was writing this book, I was completely zoned into this. For a couple of months, I think all I did was just write, read. At one point, I started probably having like dreams about this particular subject. Sometimes I'll be just memorizing and just going into certain provisions in my while I'm trying to sleep. So this is how you just have to get immersed into that subject and keep on doing that. So as I would say that research and writing, they are a very sacred and pristine form of expression. In order to get the most out of that, in order to derive the optimum result out of that, one has to let go of themselves completely and just be honest in whatever you are writing and reading. It is not something that happens overnight. I assure you this. But once it does happen, once you complete the work, you'll feel like that this is a child that you have given birth to. So I think this is how I had gone about writing.
Okay, thank you, sir.
Any follow-up you wanted to ask? Any specific follow-up?
Sir, not for now, sir. If I want to ask any question related to motor, if I am, sir, I'm in right now in second sem, and I have done with the three moot courts. So sir, in future, if I am in some, I have to attend some international moot, or I have to take ideas, or how do I contact you, sir? Can you
Certainly, I'll
share
share
me?
my email address.
Okay, sir.
Miss Jindal, she has my email address, so
Yes,
they will contact you.
yes, sir, definitely. Interns, any more questions? Any one of you regarding the SCC online, Manupatra, anything?
Sir, one more question, sir. I am using SSC online for all my research work, and I have read
Okay.
only digest notes, and then I see that it's related to my case or my matlab, memorial or things. Then I have move on to the whole judgment area. So it is the right thing, or sir, I have to do different.
It is also fine. I see. Digest. They almost cover a lot of these. Like I said, it depends on the area of law you're researching on. So, for example, taxmen they conduct wonderful research in the area of tax. So they have their digest on this particular subject matter. So they cover every bit of it. SCC they have their own forte, constitution, and even otherwise the SCC digest that they come out with the yearly review of Supreme Court judgments. That is wonderful. They give you a brilliant idea on what the subject is and what are the latest developments that have come up. You can go about this. I would always also ask you to go into a random research. Take up books. While search engines are always good, but a textbook is the primary source that you should go with. For example, if you are studying a contract law, in Indian contract, there is nothing better than I think Avtar Singh. And in case you're looking for contracts outside, Chitty on Contracts, every good library has that book. It is one of the most expensive books. So I would ask you to go to your university library. They must have a copy of it. And if which subject matter you are writing about?
Vishal?
Yes, sir.
So is asking on which subject matter are you writing your book?
Sir, 21st century. Sir, about how 21st century is going on, and what are the things are. Sir, I am writing this book in Hindi. So, sir, पहले क्या होता था, उसके बाद में फिर अभी क्या हो रहा है, और मतलब कितना जनरेशन में कितना क्या चेंज हो रहा है, और कितना क्या चेंज आ रहा है, और आगे हमको क्या चेंज देखने को मिलेगा.
But so how are you researching on SCC about this?
No, sir, I'm SSC I'm using for only moot courts and my assignment purpose or all these things.
Okay, okay. I thought you said you were writing book and you're researching from SCC on that.
No, sir, not for books. Sir,
Okay.
I have used this only for my mood codes, mood problems.
One, one.
Interns, you may write down your questions if in case you have any kind of query, or you can unmute yourself one by one. So I guess we don't have any further questions. So I would like to move with the vote of thanks. I, Riddhi Jindal, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Akaant sir for taking out time from his busy schedule and interacting with the young minds today. It was a wonderful session, sir.
Thank
Thank
you.
you so much for
Thank you.
coming here. Thank you.
Thank you so much, sir.
Thank you. Bye.
Okay.